I have more respect for a man who lets me know where he stands, even if he's wrong.
We always say in the Black Panther Party that they can do anything they want to us. We might not be back. I might be in jail. I might be anywhere. But when I leave, you can remember I said with the last words on my lips that I am a revolutionary.
New Nubian.
Evidence, Admissibility, Hearsay, and Courtroom Tactics. Presented by Dr. Jonah Sanders. Course objectives. To equip learners with foundational knowledge of evidence law, focusing on rules of admissibility, the hearsay doctrine and its exceptions, and effective courtroom tactics for presenting and challenging evidence. Course outline Module 1. Introduction to Evidence Law Module 2, Admissibility of Evidence Module 3, the Hearsay Rule Module 4, Expert and Opinion Evidence Module 5, Courtroom Tactics and Evidence Presentation Module 6, Case Scenarios and Review Quiz.
Course syllabus. Module topics cover time learning objectives. 1. Intro to Evidence Law Purpose, Relevance, Types 15 minutes understand basic evidence principles. 2. Admissibility Rules Authentication, Exclusion 25 minutes learn what makes evidence admissible. 3. Hearsay Rule Definition, Exceptions 30 minutes master hearsay doctrine and exceptions. 4. Expert Evidence Witness Types, Standards 20 minutes use expert testimony effectively. 5. Courtroom Tactics Objections, Exhibits, Impeachment 20 minutes apply tactical skills in trial settings. 6. Review and quiz scenarios plus test 10 minutes reinforce and assess learning.
Module 1. Introduction to Evidence Law. Learning objectives. By the end of this lesson, learners will be able to understand the fundamental role of evidence law in legal proceedings, explain how evidence rules promote fairness and efficiency, recognize the types of goals evidence law seeks to achieve. Part 1. Introduction. What is evidence law? Definition. Evidence law governs what information can be presented in court. It ensures that only relevant, reliable, and fair evidence reaches the judge or jury. Why it matters. Keeps trials focused, protects the rights of parties, prevents misleading or prejudicial material discussion prompt. What might happen in a courtroom if there were no rules about what evidence could be used? Part 2. Core Purposes of Evidence Law 1. Relevance and reliability. Only facts that make the case more or less likely should be allowed. Prevents confusion, distraction, and manipulation. A witness testifying about the weather during a robbery is only relevant if it affects visibility or conditions. Two, ensuring fairness, equal footing for both sides, avoids trial by character or unrelated past actions, excludes evidence that causes undue prejudice or unfair advantage. Three, efficiency and focus in trials, keeps proceedings streamlined and free from irrelevant stories or speculation. Judges can exclude wasteful or confusing evidence. Protecting constitutional rights rules support rights like the right to remain silent, right to confront witnesses, and right to privacy. Example, illegally obtained confessions may be excluded. Part 3. Practical application real-world example. A defendant is on trial for theft. The prosecution wants to bring up a 10-year-old drug charge. Question: should it be allowed? Likely no, irrelevant to the theft and may unfairly prejudice the jury. Mini quiz. What is one primary purpose of evidence law? A. Increase trial duration. B. Introduce all available information. C. Ensure fair and reliable proceedings. True or false? All relevant evidence is always admissible. False. Some relevant evidence may still be excluded due to prejudice or legality. What does prejudicial mean in evidence law? A. Harmful to the judge. B. Unfairly harms one party's position. C. Bias toward the facts. Which of the following is not a goal of evidence law? A. Fairness. B. Speed. C. Emotional storytelling. Relevance and materiality learning objectives. By the end of this lesson, learners will be able to define relevance and materiality in the context of evidence law, distinguish between relevant and irrelevant evidence, understand when relevant evidence might still be excluded, apply the concepts to basic courtroom examples. Part 1. Introduction. Why relevance matters. Definition of relevance. Evidence is relevant if it makes a fact more or less probable than it would be without the evidence, and the fact is material to the case. Relevance is the first filter all evidence must pass. Analogy. Think of evidence like puzzle pieces. Relevance ensures it belongs to the picture. Materiality ensures it helps solve the case. Part 2. Key Concepts 1. Relevance asks, does this help prove or disprove something? Even slight tendencies count. Any tendency is enough. Example. In a theft case, a witness saw the accused near the store minutes before it was robbed. Relevant, because it places the person near the scene. Two. Materiality asks, is the fact this evidence supports actually important to the case? Even if something is relevant, it must relate to a material issue. Example: a defendant's favorite color is irrelevant unless it somehow connects to the case facts. Three, when relevant evidence is excluded even if relevant, evidence can be excluded if it causes unfair prejudice, it confuses the issues, it leads to waste of time. Example: graphic crime scene photos may be relevant, but might be excluded for prejudicial impact. Part 3. Interactive Practice Scenario 1. In a murder trial, the prosecution wants to show the defendant's collection of violent movies. Question: is it relevant? Is it material? Possibly relevant, but not material unless connected directly to the crime. Scenario 2. A witness testifies the defendant once lied on a job application. Relevant to murder charges? No, this speaks to character, not a material fact in the case. Quick quiz. What does materiality refer to? A. Whether the evidence is allowed in court. B. Whether the evidence relates to an important issue. C. Whether the witness is credible. Evidence is relevant if it: A. is interesting to the jury. B. proves the entire case. C. has any tendency to make a fact more or less probable. True or false? All relevant evidence is automatically admissible. False, it may be excluded under Rule 403. Which of the following could make relevant evidence inadmissible? A. It's material. B. It's prejudicial. C. It's important to the defense. Relevance equals connected to facts. Materiality equals connected to legal issues. Relevant evidence must relate to something that matters in the case. Up next, we'll look at types of inadmissible evidence, starting with hearsay FRE 401 and 403 real case. Old Chief versus United States class handout. Relevance versus materiality. Spot the difference activity sheet. Types of evidence, direct versus circumstantial learning objectives. By the end of this lesson, learners will be able to define and differentiate direct and circumstantial evidence, understand their roles in court, recognize misconceptions about the strength of circumstantial evidence, apply the concepts using real-life examples and short exercises. Structure: Introduction to types of evidence deep dive, direct evidence deep dive, circumstantial evidence examples, and application recap and mini quiz. Part 1. Introduction to types of evidence. Evidence helps prove or disprove a fact in court. Two major types. Direct evidence proves a fact without inference. Circumstantial evidence requires the fact finder to draw a conclusion why it matters. Both types are admissible and can equally support a verdict. Part 2. What is direct evidence? Definition: evidence that directly proves a fact, no inference needed. Most common: eyewitness testimony, confessions, or video recordings. Examples: a witness says, "I saw the defendant steal the purse." Direct A security camera shows the act taking place. Direct A confession: "Yes, I did it." Direct important: direct doesn't always mean better. It can be flawed or unreliable. Part 3. What is circumstantial evidence? Definition: evidence that requires an inference to connect it to a conclusion of fact, used to build logical links to support what likely happened. Examples: the defendant's fingerprints on a murder weapon, seeing someone running away from the crime scene, a person had motive, opportunity, and fled town after the crime. Courts often remind juries, circumstantial evidence is not weaker, a case can be based entirely on it. Quick comparison table. Feature: direct evidence, circumstantial evidence, requires inference. No, yes. Common forms: eyewitness, confessions, videos, fingerprints, behavior, forensics. Admissibility: admissible, admissible. Strength in court: equal weight when reliable, equal weight when logical. Part 4. Application and practice. Scenario 1. A neighbor hears gunshots and sees the defendant holding a smoking gun. Direct or circumstantial? Answer: circumstantial. They didn't see the shooting. Scenario 2. A surveillance video shows the defendant taking money from a safe. Answer: direct. Shows the act clearly. Scenario 3. The defendant's muddy boots match prints found at the crime scene. Answer: circumstantial. Needs inference that the boots show presence. Mini quiz. Which of these is direct evidence? A. Fingerprints on a weapon. B. Eyewitness testimony of the act. C. Defendant's suspicious behavior. true or false. Circumstantial evidence is not admissible in court. False, it's equally admissible. Direct evidence is always more persuasive B, always visual C, proof without needing inference. You see wet footprints leading away from a broken window. A, direct evidence. B, circumstantial evidence. Burden of proof and standard of proof learning objectives. By the end of this lesson, learners will be able to define and distinguish between burden of proof and standard of proof, identify who carries the burden in different types of cases, understand the varying levels of proof required in civil and criminal trials, apply these concepts to real-world courtroom scenarios. Part 1. Introduction to core concepts. Why does proof matter? Courts must decide who wins, based on which side meets its legal burden. Two key ideas: burden of proof. Who has the job of proving a fact? Standard of proof. How convincing must that proof be? Part 2, the burden of proof 1, legal definition. The responsibility to prove the facts necessary to win the case. Two types: burden of production, bring forth enough evidence to proceed. Burden of persuasion, convince the judge, jury of your version of events. 2. Who has it? Criminal cases, always on the prosecution. Civil cases, usually on the plaintiff. Defense can have a burden if asserting an affirmative defense. Key rule: if the party with the burden fails to meet it, they lose. Part 3, standard of proof 1, definition. The level of certainty required to convince the judge or jury of a fact. Case type, standard of proof, explanation, criminal, beyond a reasonable doubt, highest standard, near certainty, civil, preponderance of the evidence, more likely than not, special civil, clear and convincing evidence, higher than preponderance, less than beyond a doubt. Examples: criminal case, prosecution must prove guilt beyond reasonable doubt. If doubt remains, the verdict must be not guilty. Civil case, plaintiff must show the defendant is more likely than not responsible. Family law fraud cases, use clear and convincing. Part 4, application and mini-quiz example 1. A defendant is accused of robbery. The prosecutor must prove guilt to what standard? Beyond a reasonable doubt, example 2. In a civil lawsuit for breach of contract, the judge says the plaintiff needs to meet which standard? Answer: preponderance of the evidence. Mini-quiz, what is the burden of proof? A, the amount of evidence presented. B, who must prove the case? C, the number of witnesses. Beyond a reasonable doubt applies to A, civil cases. B, divorce trials. C, criminal cases. The lowest standard of proof is A, preponderance of the evidence. B, clear and convincing. C, beyond a reasonable doubt. True or false? A defendant must always prove their innocence. False. The burden is on the prosecution. Wrap-up burden of proof tells us who must prove what. Standard of proof tells us how much proof is needed. Criminal equals very high standard, civil equals more likely than not. These rules protect fairness and ensure justice is based on evidence, not speculation. Module 2, Admissibility of Evidence. Rules governing admissibility learning objectives. By the end of this 50-minute lesson, learners will be able to understand the core rules that determine whether evidence is admissible in court, analyze the role of relevance, materiality, and competence in admissibility, identify reasons evidence may be excluded, including hearsay, privilege, and prejudicial impact, apply these rules to basic courtroom scenarios. Part 1. Introduction. What is admissibility? Admissibility means whether the court allows the evidence to be presented to the jury or judge. Governed by formal rules, federal rules of evidence in U.S. federal courts. Similar systems exist in other jurisdictions. Evidence must pass multiple legal filters to be admitted. Ask the class, what kinds of evidence do you think judges are likely to reject? Why? Part 2. Core Principles of Admissibility 1. Relevance evidence must make a fact more or less probable than without it, if irrelevant, inadmissible. 2. Materiality evidence must relate to a legal issue in dispute. Even relevant facts must be connected to something that matters in the case. Competency evidence must come from a valid source. Includes issues like witness capacity, document authenticity, etc. 4. Foundation parties must lay the foundation by showing how and why the evidence is reliable and relevant. Part 3. FRE rules that govern admissibility. FRE 402, General Rule of Admissibility, relevant evidence is admissible unless another rule or law excludes it. FRE 403, exclusion for prejudice, confusion, waste of time. Even relevant evidence may be excluded if it is unfairly prejudicial, misleading, confusing, redundant. Example, graphic crime scene photos may be more prejudicial than probative. FRE 404, character evidence of a person's character or acts is not admissible to prove they acted a certain way this time. Exceptions apply. FRE 501, privileges. Some communications are protected and cannot be disclosed. Attorney, client, doctor, patient, spousal, clergy, penitent. FRE 802. Hearsay rule. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Generally inadmissible unless an exception applies. Part 4. Grounds for exclusion. Even if relevant, evidence may be excluded if it meets any of these criteria. Unfair prejudice evidence that emotionally sways the jury. Unfairly improper character evidence of bad acts not connected to the current charge. Hearsay without exception. Unless the statement fits into one of the recognized exceptions, illegally obtained evidence. Violates constitutional rights. Privilege violation evidence that breaks confidentiality rules. Part 5. Application and practice scenarios. Scenario 1. A prosecutor introduces a video of the defendant committing the robbery. Admissible? Likely yes. Relevant material, direct evidence. Scenario 2. A friend testifies, someone told me the defendant did it. Admissible? No hearsay. Scenario 3. The prosecution brings up a defendant's 10-year-old unrelated theft. Admissible? Likely not. Improper character evidence. Class poll. Can a relevant piece of evidence be excluded? Yes, if it's prejudicial, confusing, privileged, or hearsay. Part 6. Recap and review admissibility. Legal filter applied before evidence reaches the jury must be relevant plus material plus reliable. FRE 402 and 403 are key to understanding what comes in. Judges act as gatekeepers, balancing truth-seeking versus fairness. Authentication and chain of custody learning objectives. By the end of this lesson, learners will be able to define authentication and explain its purpose in evidence law, understand what constitutes a valid chain of custody, identify methods for authenticating different types of evidence, recognize how flaws in authentication or custody can lead to exclusion of evidence. Part 1. Introduction. What is authentication? Authentication equals proof that a piece of evidence is what it claims to be. Courts require parties to establish the identity and integrity of physical and digital evidence before it's admissible. Ask the class. What would happen if anyone could just bring in a random photo or document and claim it's real? Part 2. Legal foundations, FRE 901 and 902 FRE 901. Requirement of authentication evidence must be supported by sufficient proof that it is genuine. This is typically done by testimony, documentation, or circumstantial evidence. Example: a witness testifies that a signature on a contract is the defendant's. That authenticates the document. FRE 902, self-authenticating evidence. Some documents are automatically considered authentic, including public records, certified business records, newspapers' official publications, notarized documents. No need for witness testimony to authenticate these items. Part 3. How to authenticate different types of evidence, type of evidence, authentication method, document, witness who saw it signed or can verify handwriting, photo video, person who took the photo or saw the scene, emails digital, metadata, digital timestamps, tech expert testimony, text messages, sender ID, reply context, phone records, physical objects, witness can identify it or explain how it was handled. Use testimony plus circumstances to support authenticity. Part 4. Chain of custody. What it is and why it matters definition. Chain of custody is the record of who had the evidence, when, and what was done with it. Ensures the evidence was not altered, lost, or tampered with. Applies especially to drugs, weapons, DNA, digital files. Steps in a chain of custody. Collection by law enforcement. Labeled and documented, transferred to lab or evidence locker, logged at each point, brought to court with custody, verified. Even small breaks in the chain can result in inadmissibility due to doubts about integrity. Consequences of a broken chain. Defense can argue that tampering may have occurred. Evidence may be excluded under FRE 901. Prosecution's case can collapse if key evidence is thrown out. Case example: if drugs seized in a bust are left unattended or mislabeled, they may not be allowed in court. Part 5. Application and examples. Scenario 1. A lab technician testifies that she tested blood samples but can't say who collected them or how they were stored. Issue: breaking the chain, authentication fails. Scenario 2. A police officer brings a sealed envelope labeled gun from scene A. He testifies he found it at the scene, tagged it, and locked it until caught. Result: proper chain of custody, likely admissible. Scenario 3. A party presents a printed email without the sender's address, date, or metadata. Issue: no clear authentication, needs verification. Part 6. Recap and mini-quiz recap. Authentication proves the evidence is genuine. Chain of custody tracks possession from crime scene to courtroom. Any break in these processes can lead to exclusion. Mini-quiz. What is authentication? A. Making evidence look real. B. Proving evidence is what it claims to be. C. Creating a fake document. Which of the following is self-authenticating? A. A personal diary. B. A notarized birth certificate. C. A voice message. True or false? A photo always needs a witness to be admissible. False. It may be self-authenticating in some cases or verified by metadata. What happens if the chain of custody is broken? The evidence becomes stronger B, it may be excluded C, the court ignores it. Exclusionary rules learning objectives. By the end of this lesson, students will be able to explain the purpose and function of exclusionary rules in evidence law, define illegally obtained evidence and recognize how constitutional protections apply, understand the exclusionary rule, fruit of the poisonous tree doctrine and their exceptions, analyze courtroom scenarios, and apply relevant rules. Part 1. Introduction and constitutional basis. The exclusionary rule prevents evidence obtained through violations of constitutional rights from being used in court. Most commonly tied to Fourth Amendment, unlawful searches, seizures, Fifth Amendment, coerced confessions, Sixth Amendment, denial of counsel purpose. To deter police misconduct and protect individual rights. Ask the class. If the police search a home without a warrant and find drugs, should that evidence be used in court? Why or why not? Part 2. The exclusionary rule explained definition. A judge-made rule that excludes evidence obtained in violation of a defendant's constitutional rights. Case law. Mapp v. Ohio incorporated the exclusionary rule to the states via the 14th Amendment. Key principle. The evidence is inadmissible regardless of its truth or relevance if the government obtained it illegally. Part 3. Fruit of the poisonous tree doctrine, what it means. Not only is the original illegal evidence excluded, but any evidence derived from it is also tainted and excluded. Example. Police illegally seize a phone, read texts, and find a drug house. Drugs found there are also inadmissible. Key case. Wong Sun v. United States. Evidence gained through illegal leads must also be excluded unless the connection is weak or broken. Part 4. Major exceptions to the rule-independent source doctrine. Evidence is admissible if it was obtained independently of the illegal search. Case. Nick v. Williams. Inevitable discovery rule evidence that would have been found anyway is not excluded. Case. Nix v. Williams. Attenuation doctrine. Evidence may be admissible if the connection between illegal conduct and evidence has become too weak or remote. Case. Brown v. Illinois. Good faith exception. If officers reasonably relied on a warrant later found invalid, the evidence may still be admitted. United States v. Leon knock and announce violation. Failure to knock does not always lead to exclusion. Case. Hudson v. Michigan. Part 5. Case examples and applications. Scenario 1. Police search a home without a warrant and find stolen goods. Admissible? No, violates the Fourth Amendment. Exclusion applies. Scenario 2. Officers conduct a search with a warrant, but the warrant is later found invalid. They acted in good faith. Admissible? Yes, good faith exception applies. Scenario 3. Police illegally detain a suspect, but hours later, he confesses at the station after receiving Miranda warnings. Admissible? Possibly, if the court finds the connection attenuated. Part 6. Recap points. The exclusionary rule protects constitutional rights by deterring misconduct. The fruit of the poisonous tree doctrine extends exclusion to derivative evidence. Exceptions limit the rule when evidence is obtained independently or in good faith. Mini quiz. What does the exclusionary rule do? A. Punishes officers. B. Removes illegally obtained evidence. C. Dismisses the case. What doctrine excludes evidence derived from an illegal search? Fruit of the poisonous tree. True or false? All evidence from an illegal search is always excluded. False exceptions may apply. What exception allows use of evidence that would have been found anyway? Inevitable discovery. Privileges learning objectives. By the end of this lesson, students will be able to define evidentiary privileges and explain their purpose in court proceedings, identify the key types of privileges, attorney, client, spousal, doctor, patient, clergy, penitent, and others, understand the conditions and limitations for asserting each type of privilege, apply privilege rules to legal scenarios, and determine whether evidence is protected. Part 1. Introduction to privilege. What is privilege? Privilege is a rule that allows certain communications to be excluded from evidence, even if relevant and reliable. Purpose: encourage open, honest communication in certain relationships deemed critical to society. Key feature: the privileged person generally has the right to waive or assert the privilege. Ask the class. Why might it be harmful to force a spouse or therapist to testify in court? Part 2. Attorney-client privilege definition. Protects confidential communications between a lawyer and their client, made for the purpose of seeking or giving legal advice. Elements: communication between a client and attorney made in confidence, for the purpose of obtaining legal advice. Exceptions: crime, fraud exception. If the client seeks advice to commit a crime fraud, the privilege does not apply. Waiver: client reveals the communication to a third party. Case example: Upjohn Co. versus United States corporate attorney. Client privilege applies to lower-level employees if they're communicating for legal advice. Part 3. Spousal privileges. There are two separate privileges related to spouses. 1. Spousal testimonial privilege. A spouse may refuse to testify against their partner in a criminal trial. Only exists during the marriage. The testifying spouse holds the right to assert it. 2. Marital communications privilege protects confidential communications made during the marriage, even after it ends. Either spouse may assert this privilege. Applies in both civil and criminal cases. Exceptions: crimes against the spouse or children, joint criminal activity. Part 4. Other major privileges. Doctor. Patient privilege protects confidential medical communications made for treatment. Not recognized in federal criminal courts, but applies in most state courts and civil proceedings. Clergy, penitent privilege protects private, spiritual confessions or guidance. Must be made in confidence to a religious figure. Psychotherapist, patient privilege. Strongly recognized in both civil and criminal courts. Protects mental health treatment communications. Jaffe versus Redmond confirmed this privilege under federal law. Reporter's privilege, not absolute. Some states recognize a right for journalists to refuse to reveal sources, especially in civil cases. No general federal protection, subject to balancing test in criminal matters. Part 5. Application scenario. Scenario 1. A defendant tells their lawyer about past illegal drug use unrelated to the case. Is it protected? Yes, attorney-client privilege applies. Scenario 2. A woman refuses to testify against her husband in his robbery trial. They're still married. Is that allowed? Yes, spousal testimonial privilege applies. Scenario 3. A pastor shares with police what a person confessed privately during counseling. Admissible? No, clergy penitent privilege likely protects it. Scenario 4. A patient tells a doctor during treatment that they plan to hurt someone. Protected? No duty to warn may override doctor-patient privilege. Part 6. Recap points. Privileges are exceptions to the rule of admissibility. They serve to protect confidential relationships society values. Most privileges can be waived by the person protected. There are narrow exceptions to each rule. Mini quiz. Who holds the attorney-client privilege? A. The lawyer. B. The judge. C. The client. Which of these is true about spousal testimonial privilege? A. Either spouse can assert it. B. Only applies to civil cases. C. The testifying spouse may choose to refuse true or false. Privileged communications are always admissible if they are relevant. False. Which of these is not a standard privilege in evidence law? A. Therapist. Patient. B. Police informant. C. Clergy. Penitent. Module 3. The Hearsay Rule. Definition and rationale of the Hearsay Rule learning objectives. By the end of this 30-minute lesson, learners should be able to define hearsay in legal terms, understand why the hearsay rule exists, distinguish between hearsay and non-hearsay, recognize the rationale behind excluding hearsay in court. What is hearsay? Definition. Hearsay is an out-of-court statement offered in court to prove the truth of the matter asserted. Examples. Witness says, "John told me that Mary stole the bike." A text message submitted in court to prove someone's guilt, based on what someone else said. Key terms. Declarant, the person who made the statement. Out of court. The statement was made outside of the trial. Truth of the matter asserted, using the statement to prove what it says is true. Mini activity. Classify the following as hearsay or not. He said it was raining. He said it was raining. Why is hearsay usually inadmissible? Rationale behind the rule. Lack of cross-examination. The declarant is not in court to be questioned. Reliability concerns. Memory, perception, or honesty of the speaker may be flawed. No oath taken. The statement was not made under the penalty of perjury. Jury misuse risk. Jurors may give too much weight to unreliable statements. Historical insight. The rule stems from the English common law system and was designed to promote fair trials based on direct and tested evidence. Case mention. Reverses Blastland. Highlights the dangers of using a third-party statement without cross-examination. Hearsay versus non-hearsay common exceptions exclusions. Statements not offered for truth. Admissions by a party opponent. Prior statements by witnesses under specific conditions. Examples of non-hearsay uses. Showing effect on the listener, proving notice or knowledge. Demonstrating the declarant's mental state. Activity. Analyze if these are hearsay. I heard the fire alarm, offered to show the alarm went off. I heard the fire alarm, offered to explain why the person left the building. Quick recap quiz. What is the basic definition of hearsay? Why is hearsay generally inadmissible? Name one reason the hearsay rule exists. Common exceptions to the hearsay rule learning objectives. By the end of this lesson, learners should be able to identify and define common exceptions to the hearsay rule, understand the rationale behind each exception, apply each exception to sample fact patterns, recognize when and how each exception might apply in court, Introduction to Hearsay Exceptions topics covered. Why exceptions exist. Balancing reliability with necessity, Federal Rules of Evidence overview, reminder. Even if a statement is hearsay, it might still be admissible through an exception mini-case prompt. A woman screams during a robbery. That man just took my purse. Ask, can this be used in court? Why? Present sense impression definition. A statement made describing or explaining an event or condition while or immediately after perceiving it. Rationale. Minimal time to fabricate equals reliability. Example. She's swerving into the next lane. Activity. Which is admissible as a present sense impression. He looked suspicious yesterday. He's trying to break into the house right now. Excited utterance definition. A statement made under the stress or excitement of a startling event. Rationale. Excitement limits the chance of fabrication. Example. I just saw a car crash into that tree. Indicators. Timing, emotional state of the speaker, nature of the event, mini exercise. Which qualifies as an excited utterance. Why? Statements for medical diagnosis or treatment definition. Statements made for the purpose of medical diagnosis or treatment regarding symptoms, pain, or the cause. Example, I was hit in the head with a brick and now I have blurry vision. Rule points. Must be reasonably related to diagnosis. Treatment can include how the injury happened, but not fault unless medically relevant. Quick pair activity. Which statements to a doctor are admissible? My back hurts after lifting boxes. My boss pushed me at work because I was late. Business records definition. Records of acts, events, conditions, opinions, or diagnoses made at or near the time by someone with knowledge, kept in the regular course of business. Requirements. Made during regular business activity, regular practice of business to make such a record made at or near the time by a person with knowledge or information transmitted by such a person. Examples. Hospital intake forms, attendance logs, delivery invoices, activity. Are these business records? Why or why not? A diary found in a company manager's drawer, time cards filled out and filed weekly, a one-time report created for litigation. Dying declarations definition. Statement made by a declarant who believes their death is imminent about the cause or circumstances of what they believe to be their impending death. Applies only in homicide cases, civil cases. Example. As the victim lies bleeding, James shot me in the alley. Important. Declarant must believe death is imminent. Declarant need not actually die in all jurisdictions. Class discussion prompt. Should dying declarations always be allowed? Application, quiz and discussion. Quick quiz. Which exception applies to I'm having chest pain, it started after I was pushed? Is a memo written by a secretary about an internal meeting a business record? Can a 911 call be both a present sense impression and an excited utterance? Non-hearsay uses of out-of-court statements. Learning objectives. By the end of this lesson, learners will be able to understand the distinction between hearsay and non-hearsay uses of statements, identify scenarios where out-of-court statements are not offered for the truth of the matter asserted, recognize the admissibility of non-hearsay statements in legal proceedings, apply these concepts in real and hypothetical courtroom situations. Introduction to the concept topics covered. What is considered hearsay? What is not hearsay? Statements offered for purposes other than proving the truth of the matter asserted. Definition refresher. Hearsay equals out-of-court statement offered to prove the truth of what it says. Non-hearsay equals out-of-court statement offered for a different purpose.
Types of non-hearsay uses. 1. Effect on the listener or reader. Definition: statements introduced to show how a person reacted or why they took certain actions, not to prove the statement was true. Example: statement, "The floor is slippery." Purpose: to explain why the listener stepped carefully, not to prove the floor was slippery. Activity: evaluate 3 short fact patterns and determine if the statement is used for effect on the listener. Two. Verbal acts or legally operative facts. Definition: statements that are the act itself, such as offers, acceptances, threats, or defamation. Example: I accept your offer. The statement creates a legal obligation. Other examples: libel or slander, threats in assault cases, bribery. 3. State of mind or mental condition. Definition: statements that demonstrate the speaker's state of mind, intent, motive, fear, knowledge. Example: I'm scared of Tom. Used to prove fear, not whether Tom is dangerous. When admissible, to show motive, intent, or emotional condition of declarant. Four. Impeachment or credibility purposes. Definition: prior inconsistent statements introduced not as proof of facts but to challenge a witness's credibility. Example: on stand, I didn't see the car. Prior statement: I saw the red car hit him. Use: to impeach, not as substantive truth unless another rule allows. Practice scenarios and group discussion. Instructions. Learners review 4 brief case scenarios. Determine whether the out-of-court statements are hearsay or non-hearsay. Discuss in pairs or small groups and explain reasoning. Sample scenario. A tenant tells her landlord, "There's a gas leak." Is this hearsay if introduced to show landlord's notice? Answer: non-hearsay. It's not being used to prove there was a leak, but to show the landlord was on notice. Recap and quick quiz. Key review points. Not all out-of-court statements equals hearsay. Context and purpose of statement determine admissibility. Statements for effect on listener, state of mind, verbal acts, and impeachment equals often non-hearsay. Quick quiz, 3 questions. The brakes don't work. Offered to show why the driver pulled over. Is this hearsay? I accept the job offer. Verbal act or hearsay. A prior inconsistent statement is offered only to impeach. Is this hearsay? Module 4. Expert and opinion evidence. Lay witness versus expert witness testimony. Learning objectives. By the end of this session, learners should be able to define lay witness and expert witness, understand the legal standards for admitting each type of testimony, recognize the limits of lay opinion, distinguish between factual and technical/specialized testimony. Introduction and key definitions. Lay witness, a person who testifies about facts based on their personal knowledge or observation. Expert witness, a qualified person permitted to testify based on specialized knowledge, training, skill, experience, or education. Blue Book legal basis. Lay opinion, Federal Rule of Evidence, FR 701. Expert testimony, FRE 702. Lay witness testimony. What lay witnesses can do. Testify on facts they saw, heard, or experienced directly. Offer limited opinions based on perception, e.g., he looked drunk, the car was speeding. Limitations. No technical or scientific opinion allowed. Must be helpful to understanding the witness's testimony. Example, a bystander testifying that a car was going very fast, based on watching it pass. Mini activity. Which of these are acceptable lay opinions? He seemed nervous. Based on trajectory angles, the bullet came from 15 degrees north. Only number 1 is acceptable. Expert witness testimony. What makes someone an expert? Qualifications, education, training, experience, or a combination. Judge must find them qualified and their testimony reliable. FRE 702 criteria. Based on sufficient facts or data. Product of reliable principles and methods. Witness has applied those principles reliably to the case. What they can do. Interpret scientific/technical data. Offer opinions beyond the understanding of average jurors. Examples. Forensic scientist testifying on DNA results. Medical expert diagnosing cause of injury. Case mention, Daubert vs. Merrill Dow Pharmaceuticals, established standard for reliability of expert testimony. Comparing lay versus expert testimony. Feature lay witness expert witness. Basis personal perception specialized knowledge. Allowed opinions based on first-hand observation based on science, skill, or expertise. Qualification needed no yes, court must accept qualifications. FRE Reference Rule 701 Rule 702. Key distinction. Lay equals, I saw it. Expert equals, based on my expertise, this is what likely happened. Quiz and recap. Can a lay witness say, he looked tired? Can a mechanic testify about brake failure without being declared an expert? Which rule governs expert testimony? Answers. Yes. Only if the court qualifies them as an expert. FRE 702. Summary. Key takeaways. Lay witnesses speak from observation, experts from expertise. Expert testimony must meet reliability standards and be court-approved. Knowing the difference ensures admissibility and clarity in court. Qualifications of expert witnesses. Learning objectives. By the end of this lesson, learners will be able to understand the legal criteria for qualifying expert witnesses. Identify different types of expertise accepted by courts. Apply relevant standards, e.g., FRE 702, Daubert, to real and hypothetical scenarios. Evaluate the admissibility of expert testimony based on qualifications. Introduction to expert witness qualification. What is an expert witness? A person who has scientific, technical, or other specialized knowledge that will help the trier of fact, judge or jury, understand evidence or determine a fact and issue. Blue Book Governing Law. Federal Rule of Evidence 702. Courts act as gatekeepers to ensure that expert testimony is both relevant and reliable. Criteria for qualification. FRE 702, an expert may be qualified by knowledge, field-specific awareness or facts. Skill, practical hands-on experience. Experience, years of work or practice in a field. Training, vocational or professional development. Education, academic degrees or certifications. Brain key point, no single element is required, a combination may qualify someone as an expert. Case example. U.S. v. Smith, a narcotics officer with 15 years of field experience was deemed qualified to testify on drug trafficking behavior despite lacking a formal degree. The court's role, gatekeeping function. Judicial gatekeeping, post-Daubert standard. Daubert v. Merrill Dow Pharmaceuticals, 1993, courts must assess not only the qualifications of the expert but also the methodology behind their testimony. Test tube Daubert factors. Can the theory be tested? Has it been peer-reviewed? What is the known error rate? Are there standards controlling its use? Is it generally accepted in the relevant field? Other standards. Kumho Tire Company v. Carmichael, 1999, Daubert applies to technical and other specialized knowledge, not just science. Real-world applications. Examples of experts. Medical doctor testifying on cause of injury. CPA testifying on financial fraud. Auto mechanic analyzing brake failure. Forensic psychologist offering insight on competency. Class exercise. Analyze these profiles and decide if the person would qualify as an expert. A high school teacher with 10 years of drone hobby flying experience testifying on aerial drone tech. A medical student who has completed 2 years of study testifying on cancer treatment. A certified IT professional with 8 years of experience in cybersecurity testifying on data breaches. Discuss, who would qualify and why. Challenging qualifications. Cross-examination and voir dire. Opposing counsel can challenge an expert's credentials, training, and methodology. Judges can rule to exclude the expert or limit the scope of their testimony. Tip: being designated as an expert in previous cases is not enough on its own. Quick recap and quiz. Review points. FRE 702 equals foundation for qualification. Experience plus education equals typical paths to expertise. Judges assess both qualification and reliability. Daubert sets the modern reliability standard. Quiz questions. Name 2 factors that may qualify someone as an expert witness under FRE 702. What case established the trial judge's role as gatekeeper for expert testimony? Can a person with no formal degree still be qualified as an expert? Answers: any of knowledge, skill, experience, training, education. Daubert vs. Merrill Dow Pharmaceuticals: yes, if their experience and skill meet the reliability standard. Admissibility of expert opinions, Daubert and Frye standards. Learning objectives. By the end of this lesson, learners should be able to understand the difference between the Daubert and Frye standards. Explain how courts determine the admissibility of expert opinions. Apply the admissibility standards to courtroom scenarios. Recognize the current U.S. jurisdictions applying each standard. Introduction to Expert Opinion Admissibility. Key point: not all expert opinions are admissible. Judges must first determine whether they meet certain legal standards. Blue Book: Why it matters. Expert opinions carry great weight with juries. Ensuring reliability and relevance protects fairness in trials. 2 key standards. Frye test, older, minority rule. Daubert standard, modern, majority rule under FRE 702. The Frye standard. Frye v. United States, 1923. Origin, D.C. Circuit Court. Rule: scientific evidence must be generally accepted in its field to be admissible. Pros: simple, clear focus on professional consensus. Cons: rigid, excludes emerging but valid science. Test tube example: polygraph tests often excluded because they're not generally accepted in the scientific community. Still used in a handful of jurisdictions, including California, New York, Illinois, and Florida, with variations. The Daubert Standard. Daubert v. Merrill Dow Pharmaceuticals, 1993. U.S. Supreme Court decision applying FRE 702. Gave trial judges a gatekeeping role. Core holding: scientific evidence must be both reliable and relevant. Daubert factors, used to assess reliability. Can the theory or technique be tested? Has it been peer-reviewed or published? Is there a known error rate? Are there standards for controlling its use? Is it generally accepted in the scientific community? Reinforced by Kumho Tire Company v. Carmichael, 1999. Daubert applies to all types of expert testimony, not just scientific. Joyner v. General Electric, 1997. Trial court's decision to exclude expert evidence is reviewed for abuse of discretion. Comparing Frye v. Daubert. Feature: Frye standard, Daubert standard. Origin: 1923 case, Frye v. U.S. 1993 case, Daubert v. Merrill Dow. Focus: general acceptance, scientific reliability plus relevance. Applies to scientific evidence, all expert testimony. Used in a few states, e.g., CA, New York, federal courts plus most states. Judge role: minimal gatekeeper, active gatekeeper. Visual aid: display a U.S. map showing which states follow Frye, Daubert, or a hybrid. Application practice. Scenario practice. A scientist offers a new DNA analysis method not widely used but backed by solid peer-reviewed research. Question: would it be admissible under Frye? Would it be admissible under Daubert? Discussion: likely excluded under Frye, not generally accepted. Likely admitted under Daubert, testable, peer-reviewed, low error rate. Quiz and recap. Quick quiz. What is the key requirement under the Frye standard? Name 2 Daubert reliability factors. Which standard allows consideration of novel techniques if reliable? Does Daubert apply to technical experts, e.g., mechanics? Answers: general acceptance in the field, peer review, testability, error rate, standards, general acceptance. Daubert: yes, per Kumho Tire. Summary: key takeaways. Frye focuses on general acceptance. Daubert demands reliability plus relevance, applying to all expert types. Judges act as gatekeepers, protecting the integrity of expert evidence. Most courts today apply Daubert, but it's vital to know both standards for jurisdictional differences. Using expert testimony effectively. Learning objectives. By the end of this lesson, learners should be able to understand how expert testimony fits into trial strategy. Know how to prepare an expert for direct and cross-examination. Recognize techniques to enhance credibility and clarity of expert evidence. Apply effective methods to introduce and challenge expert testimony. Role of expert testimony in trial strategy. Why use expert testimony? Explain complex or technical topics to the judge or jury. Strengthen a party's theory of the case. Counter opposing experts. Strategic uses. Civil, medical causation, engineering failures, accounting fraud. Criminal, forensic analysis, mental state, reconstruction. Blue Book tip: use experts to simplify, not complicate, your case for the jury. Selecting and preparing an expert witness. Selection criteria. Qualifications and credibility. Communication skills. Familiarity with court procedures. Preparation steps. Ensure full disclosure of expert reports under rules, e.g., Rule 26, Federal Rules of Civil Procedure. Mock examination and walkthrough of courtroom process. Prepare expert for potential cross-examination traps. Common pitfall: experts who are brilliant but poor communicators risk losing jury trust. Resenting expert testimony, direct examination. Goals on direct. Establish credibility. Lay the foundation for qualifications, FRE 702. Clearly explain findings in simple, persuasive language. Structure of direct. Qualify the witness as an expert. Explain methodology. Offer opinion. Tie opinion to the facts of the case. Sample direct questions. Can you describe your training and experience in this area? What materials did you review in this case? What conclusion did you reach? Brain tip: use analogies, visuals, and examples to enhance juror understanding. Challenging or cross-examining expert testimony. Cross-examination goals. Expose bias or lack of neutrality. Challenge assumptions or methodology. Undermine confidence in conclusions. Tactics. Attack reliability of data or tests used. Point out inconsistencies with prior publications. Question compensation and frequency of testifying for one side. Blue Book example. You earn $5,000 per testimony and only testify for plaintiffs, correct? Motion in limine, filed pre-trial to limit or exclude opposing expert testimony. Practice scenario and group discussion. Scenario. A medical expert claims a slip and fall caused permanent spine damage. Opposing expert says the injury was pre-existing. Group tasks. How would you direct your expert? What would you ask on cross of the opposing expert? Discuss strategies in pairs or small groups. Recap and quiz. Key takeaways. Expert testimony is most effective when it's clear, reliable, and strategically placed. Success depends on preparation and courtroom communication. Challenges to expert evidence can win or lose cases. Mini quiz. What are two goals of direct examination of an expert? Name one way to challenge an expert on cross. What's the purpose of a motion in limine? Module 5. Courtroom Tactics and Evidence Presentation. Objecting to evidence, when and how. Learning objectives. By the end of this 30-minute session, learners will be able to identify when an objection is appropriate during the introduction of evidence. Name common grounds for objections. Understand how to make and respond to objections effectively. Apply courtroom protocol for preserving objections for appeal. Purpose and importance of objections. Why object? To prevent inadmissible or prejudicial evidence from influencing the court. To preserve legal issues for appeal. To protect the fairness and integrity of the trial process. Key tip: timeliness is everything. Object as soon as the basis arises. Common grounds for objection. Small blue diamond 1. Relevance, FRE 401 to 403. Objection, irrelevant. Objection, probative value is substantially outweighed by prejudice. Small blue diamond 2. Hearsay, FRE 801 to 802. Objection, hearsay. The statement is offered to prove the truth of the matter asserted. Small blue diamond 3. Leading question, on direct. Objection, leading the witness. Small blue diamond 4. Speculation. Objection, the witness is guessing. Five, lack of foundation. Objection, no foundation has been laid for this exhibit/testimony. 6. Opinion testimony by lay witness, FRE 701. Objection, calls for an expert opinion by a layperson. 7. Argumentative or compound questions. Objection, compound question. Objection, argumentative. How to make an objection effectively. Steps to objecting. Stand up, if in a real courtroom. Say, objection, followed by the reason. E.g., objection, hearsay. Wait for the judge's ruling. Sustained, evidence is excluded. Overruled, evidence is allowed. Preserving for appeal. Must state the objection clearly and on the record. Sometimes followed by a motion to strike the answer if already given. Practice and application. Mini role play, instructor or pairs. Example testimony. My neighbor told me the defendant confessed. Ask. Would you object? What would be the correct basis? Answer, yes, objection, hearsay. Quick recap and quiz. Key points review. Objections prevent prejudicial or inadmissible evidence. Common grounds, relevance, hearsay, leading, speculation, foundation. Be timely and specific to preserve rights. Mini quiz, 2 questions. What does objection, lack of foundation mean? When should you object to a leading question? Answers. The attorney hasn't provided background to support the evidence. When it's used during direct examination, unless permitted. Demonstrative evidence and exhibits. Learning objectives. By the end of this lesson, learners will be able to define and distinguish demonstrative evidence from real evidence. Understand rules and foundation required for admissibility. Learn best practices for preparing and using demonstrative exhibits in trial. Apply courtroom strategies to maximize visual and persuasive impact. What is demonstrative evidence? Definition: evidence created to illustrate or explain facts/testimony in the case. Examples: maps, charts, diagrams, timelines. Accident reconstruction models. Medical illustrations. PowerPoint presentations. Photos or sketches, when not themselves part of the crime. Key concept: not real evidence, the actual knife. Not testimonial, spoken words. It helps the jury understand testimony or evidence already in the record. Related rule, FRE 611A, courts control over presentation to make evidence understandable. Demonstrative versus real evidence. Category: real evidence, demonstrative evidence. Definition: actual object from the case aid used to explain or clarify. Example: the gun used in the crime diagram showing how the gun was used. Must be authenticated. Yes, but less strictly. Can go to jury. Yes, usually, with judge's permission. Foundation and admissibility. Foundational steps to admit demonstrative evidence. Witness recognizes and confirms it reflects what it purports to show. Demonstrative fairly and accurately represents the subject. Relevance, must help the jury understand the facts. No unfair prejudice, FRE 403. Man-judge example. A doctor testifies using an anatomical diagram. Doctor, does this diagram fairly represent the parts of the body relevant to your testimony? Yes. Court may allow its use. Pushpin tip, even if not admitted as an exhibit, it can still be used during testimony, marked for identification only. Best practices for effective use. Do. Keep visuals clear, simple, and large enough to be seen. Use color and labeling wisely. Align exhibits with key parts of testimony. Prepare the witness to explain the exhibit. Offer the exhibit early in testimony to anchor the explanation. Don't. Use dramatic or emotionally manipulative visuals, risk of objection, unfair prejudice. Present without laying proper foundation. Surprise the court or opposing counsel with exhibits not disclosed. Technology in court. Use of screens, slide decks, animations, court's approval needed. Digital tools, e.g., trial presentation software like Trial Director, Sanction. Objections to demonstrative evidence. Common objections. Objection, lack of foundation. Objection, misleading/inflammatory. Objection, prejudicial under Rule 403. Objection, not properly disclosed before trial. Strategy. Prepare to respond with witness support. Your Honor, this is a fair and accurate diagram to help the jury visualize the witness's testimony. Quick exercise and quiz. Mini exercise. A witness uses a timeline of events. How would you lay the foundation? Handle an objection that it's argumentative? Mini quiz. What's the main difference between real and demonstrative evidence? Name one rule that governs demonstrative exhibit admissibility. What foundational question should you ask a witness? Answers. Real is physical evidence from the case, demonstrative illustrates facts. FRE 403 or FRE 611, A. Does this fairly and accurately represent? Impeachment of witnesses. Learning objectives. By the end of this lesson, learners should be able to define impeachment and understand its purpose. Identify and apply various methods of impeaching witnesses. Know how to introduce impeachment evidence under the rules of evidence. Understand limits, safeguards, and strategic risks of impeachment. Introduction to impeachment. Definition. Impeachment is the process of attacking a witness's credibility, not their character in general, but their reliability or truthfulness in relation to the testimony. FRE reference, FRE 607-609. Why impeach? To expose bias, inconsistency, or dishonesty. To diminish the weight of the testimony. To build your case or create reasonable doubt. Reminder, you can impeach your own witness, FRE 607. Methods of impeachment. Puzzle Piece 1. Prior inconsistent statements. FRE 613, can be oral or written. Must give witness an opportunity to explain or deny. Example, on the stand, I didn't see him. Prior statement, he definitely hit her. 2. Bias, interest, or motive. Show the witness has something to gain or a personal relationship. Example, witness is the defendant's best friend or has a financial interest. Three. Prior convictions, FRE 609. Crimes involving dishonesty or false statement equals always admissible. Felonies equals admissible subject to balancing test. Cannot be more than 10 years old unless exceptional circumstances. Four. Character for untruthfulness, FRE 608A. Reputation or opinion testimony about truthfulness. No extrinsic evidence for specific bad acts, see number 5. Five. Specific bad acts, FRE 608B. Cross-examination only, no outside proof. Example, isn't it true you lied on your job application? Six. Contradiction by other evidence. Showing the witness is factually wrong through other testimony or evidence. Not always allowed for collateral issues. Procedure and foundation. Laying the foundation for impeachment. Ask the question on direct/cross. Elicit the inconsistency or bias. Confront the witness, if required. Offer extrinsic evidence, if permitted under rules. Example script, prior inconsistent statement. You testified you didn't see the accident. Isn't it true that in your police report you wrote, the car ran the red light? Caution, for prior statements, witness must be given a chance to explain or deny, Rule 613(b). Limits and risks of impeachment. Limits. Rule 403, unfair prejudice versus probative value. Rule 608, be no extrinsic evidence for bad acts not resulting in conviction. Impeaching your own witness too harshly can damage your case. Collateral matters equals judge may exclude contradiction. Risks. Jury may sympathize with witness. Overuse may confuse or alienate the jury. May open the door to rebuttal evidence. Practice scenario. Mini exercise. Read this cross-examination. Lawyer, you said you never spoke to the defendant. Witness, that's right. Lawyer, let me direct your attention to this email where you said, after talking to Mark yesterday. Question. What type of impeachment is this? Is extrinsic evidence allowed? Answer, prior inconsistent statement. Yes, a written statement can be introduced under FRE 613. Quick quiz and recap. Review points. Impeachment equals attacking credibility, not the person. Multiple methods, each with unique rules. Know when and how to lay proper foundation. Don't overdo it, use impeachment with strategy. Quiz questions. Which rule allows for impeachment by prior convictions? Can you use outside evidence to prove specific bad acts? Can you impeach your own witness? Answers. FRE 609. No, Rule 608(b). Yes, Rule 607. Preparing evidence for trial. Learning objectives. By the end of this lesson, learners will be able to understand how to gather and organize evidence for trial presentation, identify admissibility issues and prepare foundational support, comply with rules of discovery and pre-trial disclosure, prepare exhibits for effective courtroom use and judge/jury comprehension. Overview of evidence preparation. Why evidence prep matters. Prevents surprises in court. Increases chance of admissibility. Enhances credibility with the court. Ensures smooth, professional trial presentation. Key rules to know. Federal Rules of Evidence, FRE. FRCP 26/Criminal Rule 16, Disclosure. Local court rules for exhibit handling. Gathering and reviewing the evidence. Sources. Client-provided documents. Discovery, depositions, interrogatories, admissions. Subpoenaed material. Photos, video, real objects. Public records and third-party data. Checklist for review. Relevance, FRE 401. Admissibility, hearsay. Privilege. Chain of custody, especially for physical or digital evidence. Authenticity, FRE 901 to 902. Tip, use an evidence log or matrix to track status, admissible, disputed, needs foundation. Disclosure and pretrial exchange. Civil. Under FRCP 26, parties must disclose exhibits they plan to use. Deadline, usually weeks before trial. Duty to supplement if anything changes. Criminal. Prosecutor, must turn over inculpatory and exculpatory evidence, Brady material. Defense, must disclose expert reports, alibi if used, etc. Practice tip. Create a pretrial evidence binder or digital file set. Exhibit numbers. Description. Admissibility status. Witness who will introduce it. Authenticating evidence. Foundation requirements. Testimony from a witness with personal knowledge. Chain of custody if applicable. For business records, follow FRE 803-6 requirements. For photos/videos, show time, date, and accuracy. Self-authenticating items, FRE 902. Certified public records. Official publications. Newspapers. Commercial labels. Example. Email printout, must show who authored it, when it was sent, and that it hasn't been altered. Organizing and marking exhibits. Best practices. Use clear exhibit labels, P1, D1, etc. Have 3 copies, one for you, one for opposing counsel, one for court. Create an exhibit list, indexed and summarized. Use exhibit stickers and pre-mark when allowed. Physical evidence. Secure storage. Clear chain of custody documentation. Bring handling gloves or containers if needed. Digital/visual aids. Ensure compatibility with courtroom tech. Keep backup on flash drives and printed copies. Courtroom strategy and exhibit presentation. Practice laying foundation with your witnesses. Prepare visual aids that reinforce testimony. Rehearse how and when exhibits will be introduced. Be ready with motions in limine to exclude prejudicial evidence. Anticipate objections, have responses ready. Tip: use a timeline of when each piece of evidence will be introduced in your case-in-chief. Recap and quiz. Key takeaways. Proper preparation avoids trial delays and objections. Every piece of evidence must have a purpose, a witness, and a foundation. Organize, disclose, and test your exhibits before court. Mini quiz. What rule governs pretrial disclosure of evidence in civil trials? What must be shown to authenticate a photograph? What is one benefit of pre-marking exhibits? Answers. FRCP 26-A. That it fairly and accurately represents the scene/event. Saves time and avoids confusion at trial. Module 6. Case Scenarios and Review Quiz. Hypotheticals applying hearsay exceptions and objections. Learning objectives. By the end of this 30-minute session, learners will be able to spot hearsay in trial scenarios. Apply common exceptions to hearsay, e.g., present sense impression, excited utterance, business records. Formulate and respond to hearsay objections effectively. Practice quick legal analysis in trial-style hypotheticals. Quick recap of key rules. What is hearsay? An out-of-court statement. Offered to prove the truth of the matter asserted. Generally inadmissible, unless an exception or exclusion applies. Key exceptions to focus on. Present sense impression, FRE 803-1. Excited utterance, FRE 803-2. Statements for medical diagnosis, FRE 803-4. Business records, FRE 803-6. Dying declaration, FRE 804-B2. Guided hypotheticals, group analysis. Brain hypothetical 1, excited utterance. Scenario. A woman calls 911 and says, "Help. He just stabbed me." 10 minutes later, she tells the police officer, "It was my ex-boyfriend. He stabbed me in the alley." Question: which statement is admissible under an exception to hearsay? Why? Answer: the 911 call likely qualifies as an excited utterance. The statement to police may not if made after calming down. Hypothetical 2, medical diagnosis. Scenario. In the ER, a patient says, "My back started hurting after I fell at work yesterday." Question, admissible? Answer, likely yes, statement made for medical diagnosis or treatment. Hypothetical 3, business records. Scenario. An insurance company introduces a technician's report as proof the fire alarm didn't work. Question, what foundation is required? Answer, must be a record kept in the regular course of business, made at or near the time, by someone with knowledge. Hypothetical 4, objection practice. Scenario. Prosecutor, and what did the victim's sister tell you after the argument? Defense, objection, hearsay. Judge asks, counsel, response. You answer, Your Honor, the statement is not offered for its truth, but to explain the officer's course of conduct. This is a non-hearsay use, statement not offered for truth. Hypothetical 5, dying declaration. Scenario. A man is shot and says, "I'm dying, it was Marcus who shot me." He dies an hour later. Question, can this statement be introduced at trial? Answer, yes, classic dying declaration, available under FRE 804, B2, assuming the declarant believed death was imminent. Recap and takeaway. Key tips for applying hearsay rules. Always ask, is it a statement made out of court? Is it offered for its truth? If yes, check for an exception or non-hearsay use. Be ready to object or defend using rule numbers and rationale. Common pitfalls in evidence presentation. Learning objectives. By the end of this lesson, learners will be able to recognize frequent mistakes in presenting evidence in court, understand how to correct or avoid errors related to admissibility, foundation, and objections, apply best practices for clear, persuasive, and rule-compliant evidence presentation, improve courtroom professionalism and trial advocacy skills. Introduction, why presentation pitfalls matter. Key point, poor evidence presentation can result in exclusion of crucial evidence, harm to credibility with the judge or jury, reversal on appeal, wasted trial time. Goal, strengthen technical courtroom skill and attention to procedural detail. Common pitfalls. 1. Failing to lay proper foundation. Evidence must be connected to a witness with knowledge. Example, showing a photo before establishing what it is. Fix, always ask foundational questions first. Two, improper use of hearsay. Introducing out-of-court statements without an exception. Example, she told me the defendant confessed. Fix, know and cite applicable FRE 803 or 804 exceptions. Three, introducing unauthenticated exhibits. Presenting documents without confirming their origin or accuracy. Fix. Use witness testimony to verify or introduce certified records, FRE 901, 902. 4. Losing control of the witness or evidence flow. Witness jumps ahead, evidence is confusing to the jury. Fix. Use leading questions when permitted, stay organized with exhibit lists. Five. Improper marking or handling of exhibits. Unlabeled exhibits, no copy for opposing counsel or court. Fix. Pre-mark, make copies, follow courtroom rules and etiquette. Six. Asking leading questions on direct, without justification. May result in sustained objections and broken rhythm. Fix. Ask open-ended questions unless it's an adverse or foundational witness. Seven. Overloading with visuals or demonstratives. Too many charts or confusing timelines can backfire. Fix. Keep visuals clean, relevant, and judge-approved. Practical fixes and best practices. Checklist for evidence presentation. Is this relevant under FRE 401? Has proper foundation been laid? Have I disclosed this evidence pre-trial as required? Is the witness ready to authenticate or explain it? Do I anticipate objections, and am I prepared to respond? Best practices. Rehearse evidence introduction with your witnesses. Number and label all exhibits clearly. Use a binder, digital tool, or index sheet for tracking. Keep backup copies, digital and hard. Courtroom scenario and group exercise. Scenario. A lawyer introduces a video clip but doesn't lay foundation. Opposing counsel objects, lack of authentication. Judge sustains. Questions for discussion. What did the lawyer do wrong? What foundational steps should have come first? How could the lawyer recover? Answer. Should have had a witness testify who recorded the video or could verify its contents and accuracy. Quiz and recap. Mini quiz. What is the main rule requiring proper authentication of evidence? True or false, leading questions are always allowed in cross-examination. Name one reason a photo might be excluded from evidence. Answers. FRE 901. True. Lack of foundation, unfair prejudice, hearsay within the image, e.g., text. 10-question quiz. Learning objectives. By the end of this session, learners will demonstrate understanding of core evidence law rules. Apply hearsay exceptions and objection strategies to courtroom scenarios. Identify errors and correct legal standards. Reinforce procedural knowledge in trial practice contexts. Instructions and preparation. Instructions. You will answer 10 questions. Each question includes one correct answer. Some questions are scenario-based, others are direct rule questions. Discuss answers after each question to reinforce concepts. Question quiz. Question 1, relevance. Which of the following is not a proper basis for excluding relevant evidence? A. Unfair prejudice. B. Cumulative evidence. C. Lack of authentication. D. The opposing party doesn't like it. Answer, D. Question 2, hearsay. Which of the following is hearsay under FRE 801? A. He said it was raining, offered to show he can speak English. B. She told me the brakes didn't work, offered to prove they didn't. C. I saw the accident happen. D. A business receipt offered without testimony. Answer, B. Question 3, exception to hearsay. A woman shouts, "I'm being robbed," as the crime occurs. This statement is likely A. Inadmissible hearsay. B. An excited utterance exception. C. Speculative opinion. D. Only admissible if the declarant is in court. Answer, B. Question 4, lay versus expert testimony. Which of the following can only be offered by an expert witness? A. The car was going fast. B. She seemed nervous. C. The cause of death was internal hemorrhaging. D. It was dark outside. Answer, C. Question 5, foundation. Before introducing a photograph into evidence, what must be established? A. The date it was taken and by whom. B. That it fairly and accurately depicts the subject. C. That it was approved by the court. D. That it was published. Answer, B. Question 6, objections. Which of the following is the best response to an improper hearsay objection when offering a medical record? A. It's just a picture. B. The document speaks for itself. C. It's a business record under FRE 803-6. D. The jury wants to see it. Answer, C. Question 7, impeachment. Which method of impeachment allows extrinsic evidence? A. Specific bad acts. B. Prior convictions. C. Reputation for truthfulness. D. Leading questions. Answer, B. Question 8, demonstrative evidence. A timeline of events is offered to help the jury understand a witness's testimony. It is A. Real evidence. B. Demonstrative evidence. C. Hearsay. D. An opinion. Answer, B. Question 9, expert qualification. To qualify an expert under FRE 702, the court must find A. The expert agrees with the other side's witness. B. The expert is licensed. C. The testimony is based on sufficient facts, is reliable, and will help the trier of fact. D. The expert has previously testified. Answer: C. Question 10, Courtroom Strategy. Why is it critical to pre-mark exhibits and prepare objections in advance? A. To avoid looking unprofessional. B. To ensure surprise. C. To hide key evidence from the opponent. D. To avoid laying foundation. Answer: A. Review and discussion. Discuss the rationale behind each answer. Why is one choice correct? What rule supports that answer? Why are the other answers incorrect? Use the Federal Rules of Evidence as reference points. FRE 401 to 403, Relevance. FRE 801 to 804, Hearsay and Exceptions. FRE 608 to 609, Impeachment. FRE 701 to 702, Witnesses. FRE 901 to 902, Authentication.
Thank you.